Have the authority to reclassify this pistol as a short-barreled rifle simply because it has a buffer tube?
They're done in this fashion. There's a spring-loaded lever here that allows you to adjust.
Distribution of 10 to 40 million of these braces and the implementation of your rule. Did Congress pass a law?
New law regarding pistol braces. It's actually a ruling because the ATF does not have the authority.
You're not exempting the same brace that you gave this letter to.
If the brace is submitted, we'll classify it.
It's illegal to own unless you have a permit or a tax stamp. This is legal. It's considered a piece of plastic, all right? Together, they're illegal. They need to actually make laws without congressional approval. They're really there to enforce laws.
Supreme Court just announced instant block of ATF pistol brace and short-barreled rifle. Federal courts have issued or clarified injunctions barring the ATF from enforcing the rule against members of the Firearms Policy Coalition, the Gun Owners of America, and the Second Amendment Foundation, among others. ATF pistol brace and short-barreled rifle. An ATF pistol brace is an accessory designed to stabilize and support a firearm when used with one hand. It resembles a stock but is attached to the pistol's buffer tube, allowing the shooter to brace the firearm against their forearm. Now, this improves stability and control, especially when firing with one hand. Initially, the ATF classified pistol braces as accessories and not shoulder stocks, which allowed for their legal use on pistols without converting them into short-barreled rifles. However, the classification and regulation of pistol braces have been subject to scrutiny and changes by the ATF over time.
The submitted firearm brace.
Just like that.
Distribution of 10 to 40 million of these braces and the implementation of your rule. Did Congress pass a law?
Or anywhere is accurate.
What changed is that item that was submitted was not produced and was not the item that was marketed.
To be able to assist those that might not have full use of all of their limbs or whatever else.
So you say that the brace changed, and so you had to implement this rule.
There we go.
The ATF has issued various guidance documents outlining criteria for the proper use of pistol braces. These guidelines include factors such as length of pull, overall length, and the shooter's intended use. Compliance with these guidelines helps determine whether a pistol equipped with a brace is still considered a pistol, or if it should be classified as a short-barreled rifle. A short-barreled rifle, SBR, is a rifle with a barrel length less than 16 inches, or an overall length less than 26 inches. In the United States, the National Firearms Act, NFA, regulates the possession and transfer of certain types of firearms, including SBRs. Owning an SBR requires compliance with the NFA, which involves undergoing an extensive application process, including payment of a tax stamp, background checks, and registration with the ATF. Now, to legally possess an SBR, an individual must apply for and receive approval for the firearm through the ATF's NFA process. This typically involves submitting a Form 1 application, paying a $200 tax stamp, and adhering to various requirements, such as submitting fingerprints and photographs. Once approved, the firearm is registered under the owner's name, and they can lawfully possess and use the SBR. Background: a man slayed 10 people inside of a grocery store in Boulder, Colorado by firing an AR-15 pistol while employing a stabilizing brace on it. Another person used one at a school in Nashville, Tennessee, which resulted in the deaths of 3 children aged 9 and 3 staff members at the school. There was also the employment of stabilizing pistol braces in the mass slayings that took place in Colorado Springs and in Dayton, Ohio. After a string of horrific mass slayings across the country, the administration of President Joe Biden called for increased gun control, stricter regulations on background checks, and stiffer penalties on straw purchases made on behalf of people who aren't allowed to own guns, as well as a number of other measures that President Biden referred to as just common sense. The Bureau of Alcohol, Tobacco, Firearms, and Explosives, ATF, issued a final rule in January to clarify the definition of a rifle. The rule states that a rifle is a firearm with a barrel measuring 16 inches or more that is designed to be fired from the shoulder.
Brace that this letter was responsive to. Are you telling me that this brace is exempt from your rule? This
Signed
brace
and-
exempt from your rule.
I can't sit here and classify.
This
but if
is
it's
the brace you
submitted,
wrote
we
the
will
letter.
give- It's not ruled to be attached as a short-barreled rifle. It will not be subject to the rule.
Or how many ever tax stamps you might have on your gun, because if I'm running a silencer, they might need that too.
Would you please quit telling this committee that the brace has changed and that's why you did the...
Because you have to already look at the price of everything that you want to build out, and then an additional $200 tax you have to pay.
You're not exempting the same brace that you gave this letter to.
If the brace is submitted, we'll classify it.
This definition includes firearms that have accessories that allow firing from the shoulder. In accordance with this rule, firearms that are equipped with pistol braces and are intended to be fired from the shoulder will now be regarded as short-barreled rifles, which are subject to the regulations of the National Firearms Act. Owners of such rifles are now compelled to remove the brace, register the firearm, and pay a fee, or else they'll be forced to give up the handgun or have it destroyed. Multiple lawsuits have been filed in an effort to overturn the rule. A preliminary injunction against the prohibition was issued on May 25th by a United States District Judge in Texas. This came after the Fifth Circuit Court of Appeals temporarily halted the rule from entering into force. Both were restricted such that they would only apply to the plaintiffs in their respective cases. Justice Department announces new rule. The United States Department of Justice, the DOJ, has announced that it has submitted to the Federal Register the Stabilizing Braces Final Rule. This rule makes it abundantly clear that when manufacturers, dealers, and individuals use stabilizing braces to convert pistols into rifles with a barrel of less than 16 inches, also known as short-barreled rifles, they are required to comply with the laws that regulate those rifles, including the National Firearms Act, the NFA. The DOJ made this announcement. At a meeting in April 2021 with President Biden, the Attorney General issued a directive to the Bureau of Alcohol, Tobacco, Firearms, and Explosives to investigate the problem of stabilizing braces.
To make this legal is to remove the 10-inch upper from this Daniel defense. New law regarding pistol braces. It's actually a ruling because the ATF does not have the authority. It's illegal to own unless you have a permit or a tax stamp.
Attorney General Merrick B. Garland highlighted the importance of safeguarding community safety and tackling gun violence in a statement that was made by the Department of Justice. He brought attention to the fact that Congress had, almost a century ago, acknowledged the demand for stricter regulations regarding guns with short barrels. The newly enacted regulation has the purpose of preventing anyone from sidestepping these necessary precautions for public safety by attaching accessories to pistols that have the effect of transforming them into rifles with short barrels. A further explanation of the reasoning behind the rule was provided by ATF Director Stephen Dettelbach, who placed an emphasis on the historical setting. Now, in the past, Congress had reached the conclusion that short-barreled rifles and sawed-off shotguns should be held to stricter legal restrictions. This was owing to the fact that these types of weaponry have higher capabilities in comparison to the majority of other types of firearms, as well as the fact that they can be concealed in a manner that is comparable to that of pistols. However, there are stabilizing braces that can be attached to handguns and turn them into shoulder-fired short-barreled rifles. These braces are designed to be attached to pistols. Therefore, according to the applicable statute, these accessories need to be regarded in the same manner as short-barreled rifles. These remarks show the aim behind the rule and the reasoning behind the reasoning for its implementation, which is to increase public safety and maintain consistency with current firearm restrictions that were established by Congress many decades ago.
To actually make laws without congressional approval. They're really there to enforce laws. And you can apply for that. That's one way to go ahead and make this legal. You can apply for the tax stamp right now. AR-15 pistol with pistol brace is now considered an SBR. You can apply for the tax stamp and not pay the $200 fee. It's a one-time fee.
ATF agreed to, in 2012, should not be under the jurisdiction of your rule.
Additionally, these statements emphasize the intention behind the rule and highlight the reasons behind its implementation. Because they are more easily concealed than long-barreled rifles, yet have greater destructive potential than typical handguns, the NFA has put requirements on short-barreled rifles since the 1930s. This is due to the fact that short-barreled rifles have a shorter barrel. In addition to requiring background checks and serial numbers, these more stringent laws also mandate taxes and registration, with the latter mandating that all transfers, even private transactions, be subject to background checks. When pistols are converted to rifles by the use of a stabilizing brace, that falls under the purview of the rule. The barrels of the resulting rifles typically measure less than 16 inches in length. As a result, these guns are subject to the same stringent regulations as short-barreled rifles are under the NFA. The regulation begins its mandatory application on the day it is published in the Federal Register. The regulation gives manufacturers, dealers, and private persons a period of 120 days, during which they can register tax-free any existing NFA short-barreled rifles that are covered by the rule. Other choices include removing the stabilizing brace to convert the revolver back to a pistol, or turning over to the ATF any covered short-barreled rifles you may have. There is nothing in this rule that prohibits the use of stabilizing braces on handguns or the use of stabilizing braces. The Department of Justice published a Notice of Proposed Regulation on June 7, 2021, and the ATF received more than 237,000 comments regarding the proposal throughout the open comment period that lasted for 90 days. ATF's proposed regulation: potential felons. The Bureau of Alcohol, Tobacco, Firearms, and Explosives has published a notice outlining their plans to update regulations on stabilizing braces. Originally developed to help those with disabilities shoot comfortably, stabilizing braces have become a popular firearm accessory used to legally adapt AR-style pistols into guns that can be shot from the shoulder, like the highly regulated short-barreled rifle. According to the ATF, stabilizing braces will now have to conform to a set of stringent guidelines to be considered legal. If they don't meet those standards, they, and the gun to which they're attached, will automatically become regulated as a rifle under the National Firearms Act. This isn't the first time the ATF or the DOJ have attempted to regulate this popular accessory. A similar reclassification was proposed back in December, but it was shot down due to uproar from lawmakers and the firearm community. However, after pistol-braced firearms were used in two recent high-profile mass slayings, the ATF has circled back to the issue and seems more motivated than ever. Immediate pushback. After the ATF notice was published, more than 130 representatives penned a letter to the agency and called upon the Bureau to withdraw the rule, stating that the, quote, proposed guidance is alarming and jeopardizes the rights of law-abiding gun owners. Most importantly, the lawmakers reminded the ATF that for the last decade, it had asserted that there were legitimate uses for stabilizing braces, as the accessory was designed to aid disabled gun owners who enjoy recreational shooting. Should this guidance go into effect, they wrote, a disabled combat veteran who has chosen the best stabilizing brace for their disability is now a felon. In response, the ATF claimed that this new classification won't impact braces designed to help those with disabilities. However, their proposed point-based worksheet of stabilizing brace criteria fails to make this clear for gun owners. Intentionally complicated. At 52 pages, the intricate proposal is so lengthy and establishes such specific requirements that law-abiding citizens will have no idea if their firearm is still legal. Certain prerequisites, the proposal reads, such as weapon weight and the overall length, will be applied to determine if the firearm will even be considered as a possible pistol or immediately determined to be a rifle. Furthermore, quote, design factors that are more likely to demonstrate a manufacturer's intent to produce a short-barreled rifle and market it as a braced pistol accrue more points than those that reveal less evidence. A stabilizing brace that has accumulated too many points based on these criteria will be deemed a rifle and therefore unlawful. Not only is this formula complicated, but there seems to be another hitch. The new factoring system, remarks the NRA-ILA, seems designed to ensure that few, if any, firearms can meet the criteria. Therefore, by classifying these brace pistols as short-barreled rifles, one of the most highly regulated guns on the market, the federal government is forcing 10 to 40 million law-abiding gun owners to surrender, destroy, or register their legal firearms, or face felony charges. Avoiding centralized power. Essentially, the ATF is able to add rules and reclassify weapons without holding a single vote in Congress. As a result, this significant assault on the Second Amendment will not receive its due process. This is a conspicuous confiscation of power, and it's precisely what America's founding fathers strove to avoid through the establishment of checks and balances. The Constitution's authors designed the United States government as three separate branches: the legislative, judicial, and executive. The legislative creates laws, the judicial determines their constitutionality, and the executive implements them. In certain scenarios, each branch has the power to override the others and ensure that no branch of government is able to hold too much centralized power. Unfortunately, through its unilateral proposal that would impact tens of millions of U.S. gun owners, the ATF is violating the separation of powers designed by the Constitution to limit government overreach and protect individual rights. A timeless warning. In Federalist No. 48, James Madison warned that, quote, "The accumulation of all powers, legislative, executive, and judiciary, in the same hands, whether of one, a few, or many, and whether hereditary, self-appointed, or elective, may justly be pronounced the very definition of tyranny." And this is exactly what is happening today. This stealth power grab should concern all Americans, even if they are outside the immediately impacted gun community. Mock versus Garland. The court has denied plaintiffs' motion for preliminary injunction or postponement of the effective date of the final rule. The National Firearms Act of 1934 aimed to regulate firearms, focusing on dangerous and concealable weapons used in organized crime. The NFA identifies 8 specific categories of firearms subject to registration and use requirements and associated taxes. Short-barreled rifles are relevant to this dispute as they are defined as weapons designed or redesigned, made or remade, and intended to be fired from the shoulder. The Gun Control Act of 1968 expanded federal firearms regulation to address the widespread traffic in firearms and their general availability to those whose possession was contrary to the public interest. The ATF has since promulgated rules and regulations in keeping with that delegation of authority, including by classifying particular weapons and devices as subject to or exempt from federal regulations. Since 2012, ATF has seen a proliferation of stabilizing brace devices, which were originally designed to assist people with disabilities or limited strength or mobility to safely and single-handedly fire heavy pistols.
The ATF could look at this and say, you know what, that brace is no longer, considered legal.
And then slide the whole pistol brace off. Now, this is legal. It's considered a pistol.
But for me, I don't want to give the government any more information than I already have to.
Well, the other side of that, you want to pull down, and it's pretty stout, pull down on the actual spring.
And I also don't want to have to give them extra money than I already have to. I also don't want to have to wait several months.
This is legal. It's considered a piece of plastic, all right? Together, they're illegal.
So we know it's a scheme. It's a money-making scheme. They take your $200, they make you wait several months.
When you store this, if you don't give it away or sell it or throw it away, store it a distance away from this.
And then they allow you to practice something that should be covered under the Second Amendment anyway.
The ATF published a Notice of Proposed Rulemaking, NPRM, in June of 2021, proposing amendments to 27 CFR 47.8.11 and 47.9.11 and identifying criteria by which the ATF would determine whether a weapon was a quote-unquote rifle for purposes of the NFA and GCA. The final rule modifies ATF's earlier regulations addressing how the agency would determine whether a weapon is a rifle for purposes of the NFA and GCA. The final rule on the use of a weapon with an accessory, component, or other rearward attachment is a controversial issue in the firearms industry. The final rule, which took effect for newly made or transferred firearms, requires individuals already possessing subject firearms to come into compliance by registering, permanently modifying, or disposing of them in accordance with ATF instructions. The final rule does not implement a weighted point system, and the final rule took immediate effect for newly made or transferred firearms. Plaintiffs William T. Mock, Christopher Lewis, Maxim Defense Industries LLC, and Firearms Policy Coalition Incorporated have sued defendants Attorney General Merrick Garland, the United States Department of Justice, Director of ATF Stephen Dettelbach, and ATF. Mock and Lewis are Texas residents who own at least one braced pistol and would purchase others in the immediate future but for the final rule's additional regulatory requirements. FPC is a nonprofit organization that defends and promotes its members' constitutional rights, advance individual liberty, and restore freedom through political and legal advocacy and public education. The plaintiffs argue that the final rule infringes on their Second Amendment rights, violates the First Amendment by chilling speech, runs afoul of the Fifth Amendment's due process guarantee, violates the Constitution's structural provisions, violates the APA as it was issued in excess of the ATF statutory authority, and violates the APA's procedural requirements.
Not in the same safe, not in the same car, not in the same bag. Keep them separate.
When it comes to brace technology for pistols, there really wasn't all that much.
They, the ATF, do not want you to put a rifle sight on a pistol.
You know, the braces were a lot different back then. Most of the time you just saw people with like a foam cover over the buffer tube.
They don't want you to shoulder it and have a sight that requires a cheek weld with maybe a 1 or 2 inch eye relief.
These brace companies started coming out and the braces started getting better and better and better.
You can't put any padding on here or a tennis ball on here or anything back here to help you shoulder this.
You already have it. It's legal in its current configuration, and if you change your mind, you can change your mind.
The court addresses whether any of the plaintiffs' claims are substantially likely to succeed on the merits, beginning with the violations of the APA before turning to the constitutional questions. The APA requires reviewing courts to hold unlawful and set aside agency action, findings, and conclusions found to be in excess of statutory jurisdiction, authority, or limitations, or short of statutory right. When an agency is given authority to administer and enforce a particular statute, they must often interpret the relevant congressional enactments in carrying out that charge. Courts have regularly recognized ATF's authority to interpret and apply the statutes that it administers, including the NFA's statutory definitions. The final rule, which purports to identify the criteria by which enforcers will make that determination, does not appear to contradict the statutory definition of rifle. The statutory definition of rifle uses terms such as designed, redesigned, remade, and intended, words that necessarily require the enforcing agency to evaluate objective weapon characteristics and perhaps conduct to decide whether a particular firearm is subject to the NFA. The final rule purports to identify the criteria by which enforcers will make that determination, but does not, as plaintiffs suggest, rewrite the definition itself. Thus, it does not appear that the final rule so clearly contradicts the statutory definition of rifle that preliminary injunctive relief is in order. Defendants contend that the final rule is merely interpretive, not substantive, and thus the logical outgrowth test does not apply. The court finds for purposes of injunctive relief that the final rule likely satisfies the logical outgrowth requirement. The plaintiff's primary argument is that the final rule is not a logical outgrowth of its predecessor because the final version abandoned Worksheet 4999, the point system indicating how ATF would classify a firearm as a rifle based on objective characteristics and instead utilizes a subjective six-factor test. The court finds that plaintiffs have not demonstrated a substantial likelihood of success on the merits of this claim. The final rule, in this case, is a controversial regulation that has been criticized for violating the Constitution's structural protections in the First, Second, and Fifth Amendments. The plaintiffs argue that the final rule runs afoul of the Constitution's procedural protections, as it is an unreasonable construction of statutory terms and a clear example of the agency's unlawfully creating law. They also argue that the regulation chills speech by allowing the agencies to more stringently regulate firearms based on statements made by manufacturers and other third parties, thus chilling speech. The regulation also chills speech by threatening to reclassify pistols as rifles based on what manufacturers and others say or write about particular weapons.
So I can actually hold it in front of my face, and there's not a lot of recoil, so I don't have to worry about this thing jumping back at me. I can hold it right here.
Look, this is a pistol. This is a pistol brace. It's perfectly legal in this configuration.
Ruling is now in the National Registry as of January 31st, 2023.
The ATF is an agency that oversteps its boundaries all the time.
So if you got a pistol brace, take steps to protect yourself. Either take it off right now.
The ATF is not supposed to make law. That is supposed to be left up to Congress.
Or just take it off and store it far away. You'll be safe.
It could make criminals out of law-abiding citizens, and they've done that in the past.
The plaintiffs argue that the final rule is void for vagueness and violates the Fifth Amendment's guarantee of due process. They argue that the regulation is unconstitutionally vague because it permits ATF to apply a set of non-dispositive criteria to decide whether a weapon is subject to the National Firearms Act. However, the court finds these arguments unavailing as they do not show a substantial likelihood of success on the merits of their Fifth Amendment claim. The plaintiffs also raised two Second Amendment claims. First, they claim that the final rule, quote, impermissibly infringes on the right of the people to keep and bear arms. They argue that when firearms are in common use at the present time, they cannot be banned. However, their first argument fails because the final rule does not ban stabilizing braces or firearms equipped with them. The Second Amendment does not bar the imposition of traditional registration and licensing requirements commonly associated with firearm ownership. The final rule only regulates stabilizing braces when they are attached to a firearm, as confirmed by the language of the final rule and the plaintiff's briefing. The court cannot conclude that the final rule substantially likely violates plaintiff's Second Amendment rights, as the briefing provided is not sufficient to justify the extraordinary remedy of preliminary injunctive relief. The court finds that plaintiffs are not likely to succeed on the merits of their Second Amendment claims at this juncture, and therefore, the court denies their request for injunctive relief or postponement of the final rule's effective date. The court's decision is based on the lack of historical evidence of similar government regulations. Appeals court partially blocks ATF's pistol brace rule. A federal appeals court has temporarily blocked the Bureau of Alcohol, Tobacco, Firearms, and Explosives from fully enforcing a new rule regulating guns equipped with pistol braces, a popular gun accessory that has been used in some recent mass slayings. The scope of the court's injunction is likely to be limited, however, and it is unlikely to prevent the ATF from enforcing the rule nationally. The Fifth Circuit Court of Appeals, which covers Texas, Louisiana, and Mississippi, granted the injunction on May 23rd in response to a court challenge attempting to block enforcement of the ATF's rule.
Remove it or you become a criminal, and people get worried about that, you know?
Unfortunately, because if I were to take this stock and throw it on that pistol, well, that's an illegal SBR.
The ATF decided to change a regulation or an interpretation of the regulation, and so they may just want to SBR right off the bat. You know, misinterpretations by the ATF in the future. And so that could be one reason why somebody might want to SBR.
Pistol braces are popular accessories intended to increase the accuracy and stability of AR-15 style pistols. The rule requires owners of the devices to either remove and destroy the accessories or register the braced firearms with the ATF as short-barreled rifles. Until May 31, doing so was free, but going forward, registration will require a $200 tax stamp. In granting its injunction, the appeals court appeared to only block enforcement against the plaintiffs in this specific case, Mock versus Garland. The plaintiffs include William Mock and Christopher Lewis, two Texans who own braced firearms, Maxim Defense, a company that sells firearms equipped with pistol braces, and the Firearms Policy Coalition, a pro-gun rights legal advocacy group. After the FPC requested clarification, the court wrote that the injunction also applies to members of the coalition and customers of Maxim Defense. Mock versus Garland is one of more than half a dozen pending lawsuits over the rule. In the days leading up to the May 31 deadline, 3 other federal judges in the Fifth Circuit followed suit and issued separate injunctions, barring the ATF from enforcing it against members of the Gun Owners of America, Texas state employees, and the Second Amendment Foundation. The rulings are a significant blow to the ATF's plans to regulate pistol braces, but they are not national injunctions and have only been issued by courts in the conservative Fifth Circuit. The agency is still able to carry out enforcement against other owners and sellers of pistol-braced firearms. The Department of Justice and ATF declined to respond to questions from the Trace seeking clarification over whether the appeals court order would affect its plans to enforce the rule. Quote, ATF is unable to comment on this litigation related to short-barreled rifles. The agency's Deputy Chief of Public Affairs, Eric Longnecker, wrote in an email to the Trace. Gun owners use pistol braces to increase the accuracy of assault-style pistols, weapons that combine the maneuverability of a handgun with the increased firepower and capabilities of rifles while maintaining concealability. While pistol braces were originally marketed as a way to stabilize a firearm against the shooter's arm, they can also be placed against the shoulder like a typical rifle stock.
As long as you don't intentionally shoulder this guy, right, when you're shooting, it's fine.
They own multiple pistols. You know, I have a 9mm, 10mm, 7.62 by 3.9. We're pro Second Amendment, but at the same time, we want to take your Second Amendment rights away from you.
It is adjustable for that a different length of pull or whatever else you might need with it.
Estimates from the ATF and the Congressional Research Service show that millions of pistol braces may be in circulation. The Biden administration first proposed regulating pistol braces in 2021, following a mass slaying in Boulder, Colorado, in which a shooter used a firearm equipped with one of the devices to slay 10 people at a grocery store. The shooter, who slayed 6 people at a Nashville Christian school in March, also used a firearm equipped with a pistol brace. The rule has been met with fierce resistance from pro-gun rights groups and Republicans since it was introduced. The rule changed reclassified guns previously considered pistols as short-barreled rifles if they are equipped with a pistol brace and have a barrel shorter than 16 inches. Doing so brings those firearms under the purview of the National Firearms Act, a law that has imposed tight restrictions on weapons like machine guns since the 1930s. The injunction is unlikely to stay in place for long. The Fifth Circuit has scheduled oral arguments on June 29th in New Orleans. Factoring firearms with stabilizing braces. On January 13, 2023, the Attorney General signed ATF Final Rule 2021R-08F, quote, factoring criteria for firearms with attached stabilizing braces, amending ATF's regulations to clarify when a rifle is designed, made, and intended to be fired from the shoulder. The final rule was published in the Federal Register on January 31, 2023. The rule outlines the factors ATF would consider when evaluating firearms equipped with a purported stabilizing brace or other rearward attachment to determine whether these weapons would be considered a rifle or short-barreled rifle under the Gun Control Act of 1968 or a rifle or firearm subject to regulation under the National Firearms Act. The rule's amended definition of rifle clarifies that the term designed, redesigned, made, or remade and intended to be fired from the shoulder includes a weapon that is equipped with an accessory, component, or other rearward attachment, for example, a stabilizing brace, that provides surface area that allows the weapon to be fired from the shoulder, provided other factors, as listed in the definition, indicate the weapon is designed and intended to be fired from the shoulder. This rule does not affect stabilizing braces that are objectively designed and intended as a stabilizing brace for use by individuals with disabilities and not for shouldering the weapon as a rifle. Such stabilizing braces are designed to conform to the arm and not as a buttstock. This rule is effective on January 31, 2023, the date it was published in the Federal Register. If the firearm with the stabilizing brace is a short-barreled rifle, affected persons have 120 days from the date of publication to register the firearm tax-free, which is May 31, 2023. Other compliance options provided under the final rule are the following: remove the short barrel and attach a 16-inch or longer rifled barrel to the firearm, permanently remove and dispose of or alter the stabilizing brace such that it cannot be reattached, turn the firearm into your local ATF office, and destroy the firearm. Challenging ATF stabilizing brace rule. The Bureau of Alcohol, Tobacco, Firearms, and Explosives, ATF, finalized its pistol brace rule in 2021, leading to lawsuits by vigilant watchdogs like the Second Amendment Foundation and Rainier Arms. The final rule was published in the Federal Register and legal floodgates opened. The largest lawsuit was initiated by the Firearms Regulatory Accountability Coalition, FRAC, which joined with the inventor of the pistol brace, Alex Bosco, manufacturer B&T, and 25 U.S. states. Other challengers included Gun Owners of America, the Texas Public Policy Foundation, and the Firearms Policy Coalition, FPC. The lawsuit filed by FPC and Maxim was the first to draw a substantive ruling from a court on the validity of the pistol brace rule. Judge Reed O'Connor denied FPC's motion for a similar injunction against the brace rule. The U.S. Court of Appeals for the Fifth Circuit granted an injunction to FPC and Maxim, but the courts are split, and the only federal court of appeals to take action issued only a temporary injunction. The SAF and FPC injunctive rulings are significant victories, but they leave uncertainty regarding the future treatment of pistol braces. Removing an ATF pistol brace. To provide an explanation on how to remove an ATF pistol brace, I'll break down the process into several steps. Additionally, the specific method of removing a pistol brace can vary depending on the design and attachment system used. Therefore, it's crucial to refer to the manufacturer's instructions for your particular brace. With that in mind, here's a general guide on removing an ATF pistol brace. Step 1. Unload the firearm and ensure safety. Before beginning any work on a firearm, make sure it is unloaded and the chamber is empty. Verify that the magazine is removed and that there are no rounds in the firearm. Keep the muzzle pointed in a safe direction at all times. Step number 2. Understand the attachment system. Different pistol braces may use various attachment systems such as screws, bolts, or latches. Familiarize yourself with the specific mechanism used in your brace to understand how it is secured to the firearm. Step number 3. Gather tools. Depending on the attachment system, you may need certain tools to remove the pistol brace. Common tools that might be required include screwdrivers, Allen wrenches, or torque wrenches. Ensure you have the appropriate tools on hand.
They're done in this fashion. There's a spring-loaded lever here that allows you to adjust.
Step number 4. Identify attachment points. Examine the pistol brace and locate the attachment points where it connects to the firearm. This could be a buffer tube, a rail, or another interface specific to your brace model. Step number 5. Remove attachment hardware. Using the appropriate tools, carefully remove any screws, bolts, or other fasteners that secure the pistol brace to the attachment points. Take note of the location and orientation of any washers, spacers, or other components as you remove them. Step number 6. Slide or lift the brace off. Once the attachment hardware is removed, you should be able to slide or lift the brace away from the attachment points. Some braces may have a snug fit, so gentle wiggling or rocking motions may be necessary to release it completely. Be cautious not to damage the firearm or any other accessories during this process. Step number 7. Inspect and secure the firearm. After removing the brace, inspect the firearm for any damage or wear that may have occurred during the removal process. Ensure that the attachment points are secure and free from any debris or obstructions. If necessary, clean and lubricate the attachment points before proceeding.
Have the authority to reclassify this pistol as a short-barreled rifle simply because it has a buffer tube.
And step number 8, legal considerations. It is crucial to understand the legal implications of removing a pistol brace. Removing the brace may change the classification of the firearm, potentially subjecting it to different regulations or requirements. In some cases, removing the brace might render the firearm an SBR, short-barreled rifle, which could require additional licensing and registration under the National Firearms Act. Make sure to research and understand the legal implications specific to your jurisdiction before making any modifications. Please note that the instructions provided here are for informational purposes only, should not be considered as legal advice. Always ensure you comply with local firearm laws and regulations and consult with a knowledgeable professional if you have any doubts or questions. And that's all for this video, folks. We'll see you next time at the next one.